Morning.
Morning.
May it please the court. My name is Joseph Lang from Carlton Fields. At council table is my partner Alexandra Bly, and we represent Wells Fargo Equipment Finance. We're the appellant here. I'd like to request 3 minutes for rebuttal. The issue in this appeal is specific personal jurisdiction. The trial judge dismissed this case for lack of personal jurisdiction. I think in reading the briefs, sometimes the arguments seem to blend over to the merits. The judge never reached even a motion to dismiss for failure to state a claim. This has been thrown out on personal jurisdiction, and that's what we're here appealing. Prime Bank made an over-collateralized loan to Mr. Carballo, who is a resident of Florida, right here in this district, made that over-collateralized loan in 2013 when it had actual knowledge that Mr. Carballo was in a dispute with Wells Fargo over $3,500,000 that he owed on a surrendered Challenger jet. He had borrowed money to buy a private jet, and Wells Fargo had to reclaim that jet and was in litigation. And on Mr. Carballo's financial statement that he gave to Prime Bank when he was seeking this loan, he lists $3,500,000 still in dispute. So at a minimum, there's that much still in dispute that Prime Bank knows about when it decides to make this loan to Mr. Carballo. They also
Let me ask you this though, and I know you're getting to it, but I'm really curious to hear your bottom line as to how you believe that these proceedings, the underlying proceedings, supplementary, do not arise or do not arise from the mortgage that Prime held on this homestead property. Tell me that connection that's necessary for jurisdiction.
It's very simple. But for that mortgage on real property in this district, the loan never happens. Prime Bank acknowledges that. It's not a multi-step, logical process like they say in the answer brief. It doesn't take a lot of ducking and weaving. But for, that's the age-old causation test. But for the mortgage on real property in this district, the loan by Prime Bank doesn't happen. Prime Bank's own person acknowledges that. Their corporate representative, the loan officer, acknowledges that but for that mortgage in this district, that loan doesn't happen.
Are you suggesting though that the but for analysis is synonymous with the arise from?
Arise from doesn't even, Your Honor, require that level. You know, we cite the City Corp case from the first DCA. You just need to have a general connexity. You don't need actual causation. But in this case, we actually have actual causation. We have but for causation that if it were not for that mortgage in this district, this loan never would have been made. And if this loan had never been made, the proceeding supplementary never would be necessary because we would be able to move directly against the assets and stocks. Because Prime Bank had no interest in doing a loan based only on the assets and stocks. They had to have the mortgage. Their loan officer says that. So they come into Florida. They avail themselves of jurisdiction in Florida to take a mortgage on Florida property. They knew that if the loan went belly up, they would have to come to Florida to foreclose. The structure of the asset package for the collateralization relies heavily on the fact that this is homestead property in Florida. So they take advantage of the homestead exemption because if it was not homesteaded property, it would be much more easily attacked directly by other creditors. So Prime Bank takes advantage of this property being homestead property when they come and they make this loan and do a single collateral package that is 200% of what they are owed.
Okay, so in these proceedings supplementary, appellant is seeking to void the loan and the liens on this Florida residence on a claim of a fraudulent transfer? I mean, is that essentially the argument?
We have 4 counts, and I'm happy to talk about, but they all arise out of 726-105. But the 4 counts, we have 2 counts for fraudulent transfer, and we have 2 counts for obligations incurred. But they all are basic, in concept, they're like fraudulent transfer counts.
Okay, but they all have to deal with this Florida mortgage.
They all involve this
Involve
Florida.
this Florida
What we're
mortgage.
trying to do is unwind the entire collateral package. Now, we're very candid. We are not trying to weave around and try to foreclose on a homestead. Wells Fargo acknowledges they cannot foreclose on a homestead, but that really takes the eye off of what we need to be focused on for personal jurisdiction. For personal jurisdiction, it's not whether the actual remedy at the end of the day is to foreclose on that homestead. What Wells Fargo wants at the end of the day is to get at those stocks and assets that are encumbered because it's an over-collateralized loan. But what needs to be focused on is that the asset package, it's the combination of the mortgage in Florida and the leaning of the assets in Oklahoma that created an asset package that's over-collateralized, and it was using the mortgage in Florida to do that we are trying to unwind. That's the basis of the cause of action. The remedy, goes to another day. We haven't gotten nearly that far in this lawsuit. We got thrown out on personal jurisdiction, and this bank came in and took a mortgage on Florida property, would have to come back and foreclose. This property is recorded in this district. The debtor's in this district. We have a $7+ million judgment against the debtor in this district that Prime Bank knew about. And I know this is in the briefs, but I want to make sure I've jumped ahead. I haven't gotten this out. I mean, this is not an arm's length transaction. We need to be very, very clear. This is not just a national bank having an arm's length transaction where then they are being hailed into Florida court and they're an Oklahoma bank. This bank is a friend of this debtor. The whole reason this loan took place is that he is a friend of the bank. And when we say friend of the bank, he's one of the original investors in the parent company of this bank. He's the second largest shareholder in the parent corporation. He's friends with the founder, and this bank has never made a loan anything like this before, where the person being loaned money has active disputes with other lenders, with other creditors. The testimony in the record is we've never made a loan in a situation like this before, where the borrower is in active dispute with other creditors. This is all taking place because he's a friend of the bank and they're trying to help out the friend of the bank, and they're using a Florida mortgage and Florida homestead laws to make that happen.
Is friend of the bank, is that a term of art, or is that something that just was coined here in this litigation, friend of the bank?
Oh, I don't think that it's a term of art, but I think it's fair to say that this guy is an insider given his shareholder status. He's the second largest shareholder of the parent corporation, but I think friend of the bank came out in the deposition, and it's a pretty good soundbite.
Yeah, it is a good soundbite.
And so it's carried through.
Well, the trial court, when it took a look at 49.193183, the long arm statute, when the trial court looked at the language there, it determined that this was not an action on the mortgage. And just the mere fact that the real property subject to Prime Bank's mortgage is located here in Florida is not enough. How do you respond to the trial court's finding there? I mean, when he says this is not an action on the mortgage.
Right. I think
Is that required for jurisdiction?
No, I don't think it needs to be. I don't think it needs to be an action.
On the mortgage.
I don't think it needs to be a foreclosure action. That's clearly not what the plain language of the statute says. It says arises from a mortgage.
Arising from a mortgage.
It doesn't say an action on a mortgage. It says arises from a mortgage. And here we clearly arise, as I said at the outset, this is but for. If it were not for that mortgage, we wouldn't be here today, and that loan would not exist, so it wouldn't be over-collateralized. And so this action, whatever you think of the merits of our action, which is for another day, I mean, but this action clearly satisfies personal jurisdiction because it arises directly from this mortgage. We wouldn't be here, we wouldn't be filing this lawsuit if it weren't for that mortgage in Florida.
But, and I think you've already addressed this, but nonetheless, perhaps it bears repeating. But your opponent's saying, okay, that may be all good, but the fact is, it's Homestead. And so ultimately, the mortgage that you're talking about, among other things, it leads to homestead of property, which the bank is not going to be able to touch anyway.
Right, and I have numerous responses. First, that goes to the merits, and we haven't been able to get that far. But second, there's a distinction between what your remedy would be, between our ability to actually foreclose on a homestead, which we're not trying to do, and considering the homestead as part of a package that allowed for a fraudulent over-collateralization. So considering the amount of that piece of property does nothing to jeopardize Florida's homestead exemption or the policy of the owner of the homestead getting an exemption. Prime Bank's not the owner of that. And so considering the asset package as a whole to determine that it's 200% of what was borrowed doesn't offend any homestead policies. And we don't have to be able to execute on the homestead at the end of the day for this court and the trial court to look at that asset package and use the total amount of the asset package to determine that it's been over-collateralized. I want to go back to the legislative intent when this statute, the plain language of the statute, was amended in 1993. It was clearly to expand the scope of our long-arm statute to touch mortgage holders who are out of state, mortgagees who are out of state. And the fact that the trial judge got off the rails here is a little bit evidenced by his explanation of why that statute was changed. In the transcript, he says he thinks that statute was changed to protect out-of-state lenders so that they would have standing to bring actions in Florida. Well, that flips the analysis around. There would be no personal jurisdiction question about an out-of-state lender bringing an action in Florida. That's a standing question. Here, the question is personal jurisdiction, and that clearly is not why they changed the language of the statute. They were trying to change the language of the statute so that people suing in Florida could bring out-of-state mortgagees into Florida court. And that's why the statute was changed, and we fall squarely within it because this does arise directly from this mortgage in Florida.
Let me ask you this. The trial court never reached the minimum contacts issue. So if we were to agree with you that you fall within the long-arm statute, do we need to send it back for the trial court to rule on the minimum contacts issue, or should that be something that we review at this point in time?
Our position, Your Honor, is that you can review it as a matter of law. That based on this record, it's clear that Prime Bank would anticipate and should have anticipated being hailed into court in Florida, and that you can make that determination as a matter of law. But certainly, you know, my job here today is to get the error in reading the plain language of the long-arm statute reversed. And I would prefer to get it reversed with directions to let the case proceed because minimum contacts are also satisfied. But at a minimum, it ought to go back for the trial judge to evaluate minimum contacts.
But is the only contact the collateralization using this mortgage? Or do they have other contacts that we could consider?
They have two other loans in Florida, but our primary focus on minimum contacts would be, you know, specific jurisdiction.
This loan.
On this loan, and for this, you know, that there wouldn't be general jurisdiction under federal due process to haul them into Florida for any purpose. But on this particular loan, to haul them in on this mortgage, an action arising from this mortgage, does not offend due process at all, and we think you can make that ruling as a matter of law. I've talked a lot, so I'm going to reserve my last 30
Thanks.
seconds. Thank you.
May it please the court, my name is Mark Levy from Brinkley Morgan. Along with me is Brent Trapana from my firm, and we represent Prime Bank of Oklahoma, which is a small community bank located in Edmond, Oklahoma, that specializes in personal and small business accounts. We believe that there are two fairly simple questions that need to be resolved in this appeal. Number one are, do Wells Fargo's claims directly arise from the mortgage in order to satisfy the long-arm statute? And two, does the existence of this mortgage satisfy minimum contacts?
Does the answer to the first question necessarily dictate the answer to the second?
I don't believe that it does, Your Honor. Even if Wells Fargo were to satisfy the long-arm statute and technically be within the language, they still need to satisfy minimum contacts, as does every case.
I understand that there's a two-part requirement. I guess my question is, does satisfaction of one necessarily satisfy the other? And I guess your answer is no.
My answer is no.
You just said when you were saying that, one issue is whether or not this cause of action, and you quoted, directly arises from holding a mortgage on real property within the state. Is that language in the statute? Because appellant has made some but-for arguments that would not necessarily fit within a directly arising.
Yeah.
He suggests that when you look at the circumstances, the fact that without the Florida mortgage, there would be no loan. Without the loan, there would be no reason for the proceedings supplementary. So his argument isn't necessarily that this cause of action directly arises from holding a mortgage. But is that what you're saying, that the language is in the statute, directly arising? And does that make a difference?
That's language from case law, Your Honor, and it's cited in numerous cases in all of the briefs, and that language is that in order for a claim, whether it relates to any of the prongs of 48.1.93, the claim needs to arise from, in this case, the mortgage, and that means direct affiliation, nexus, or substantial connection between, and this is important, the cause of action and the mortgage. Because when Judge Sicklin asked counsel about what is that connection, they give you the first part of the connection. They say, without that mortgage, there wouldn't have been a loan. See, there's a direct connection. But they skip the second part as to how the making of a loan applies to the causes of action that they've actually alleged, which are fraudulent transfer and fraudulent obligation. And there were questions from the bench about how does the homestead play into this? And it has to do, in large part, in the discussion on minimum contacts about whether or not Prime Bank reasonably anticipated being held into court. But what it also has to do, and counsel couches this as calling a merits-based argument, when you're making a fraudulent transfer claim, and it's impossible to have a fraudulent transfer involving exempt property because it's exempted from the language of the statute. In order to have a transfer, you need to transfer an asset. The definition of an asset does not include exempt property. And so certainly a mortgage on exempt property, the interest that they're saying was transferred, I presume is the security interest in this homestead property. Just by operation of the statute, you can't have a fraudulent transfer of exempt property. And so that's why we're saying, to the extent they're trying to bring this exempt property in and trying to say that their claims are tied to it, when they couldn't ever prevail on those claims because it's not part of the definition of what a fraudulent transfer is, we just say that that's improper. And you can't try to falsely create a nexus between claims that can't ever get off the ground in this property.
But let me ask you this along those lines. I mean, I understand your argument. What your opponent is saying as it relates to this whole issue of the homestead exemption is, hey, panel, don't fall for that bright, shiny object, because we are alleging that this Oklahoma bank was up to their eyeballs in fraud. And we want to thereby use proceeding supplementary, which are available to us. And yes, it is only because of the mortgage, but that mortgage, albeit homesteaded, is the very nucleus of the fraud that this Oklahoma bank has perpetrated upon us, Wells Fargo. And that's their argument. So I guess I'm asking, what about the argument that, yeah, it is homesteaded, but that's not the point, because it's that homestead property is again in the middle of what we, Wells Fargo, is alleging is a fraud perpetrated on us.
You're correct, right? You don't really need to get to that, because you just need to get to the language from the case law that I was reciting
Right.
to Judge Taylor. And that is that this type of claim needs to arise from the mortgage, and the case law defines that to mean direct affiliation, nexus, or substantial connection. It's not that you can go through, but for the mortgage, we wouldn't have the loan, and but for the loan, we wouldn't have these causes of action. That there's too much that it's just not direct. It's not a direct action on the mortgage. I can kind of state the negative over and over, but I don't quite know how to do it better than that. It's simply not direct when you have to go through multiple steps to explain why it's direct. The types of cases that would be directly arising from the mortgage are foreclosures, partition actions, quiet title cases, things like that. But talking about a situation where we have these claims and this property is part of a collateral package, it's simply not direct, and their claims do not directly arise from this mortgage, and therefore we think it can be resolved right there. As to answer your question, Judge May, we also think we have opposite views of how this record, they read the deposition of our loan officer to say that something nefarious was happening. We look at it and say, good job, you got collateral to protect the bank from this loan and comply with all the banking regulations.
Yeah, perspective is everything.
Perspective is everything. And that's, when you talk about a situation, they say, well, you intentionally took this Florida collateral, and therefore you're taking advantage of the laws of Florida, and of course you should know that you're going to be held into court in Florida. One real important fact here is actually one of the things that they're complaining about, and that is the bank took a package of collateral. That's true.
Did the bank actually ask for this house, or was a house offered up as collateral?
No, they asked for it, and that's something that's referred to both in their briefs and in the complaint itself.
And that but for having this house as part of the collateral, they would not have given the loan?
I believe that's true. And Mr. Carballo, again, is alleged in the complaint and argued in the brief, wanted them to take assets in a property called Emerald Falls, so he came to them and said, we need some money for this Emerald Falls project. It's a golf course in Oklahoma. Will you loan us some money? And they said, well, yep, sure, we'll talk to you about it. How are we going to do this? We want you to take the collateral in Emerald Falls. No way, we're not going to do that. We'll take, first, there was an initial loan of $1.2 million. Then they came back shortly after we said we need more. They loaned a total of 3, which was really 1.8 more because they were taking out the first 1.2. And they said, if we're doing this additional amount of loan, we need some way to make sure that the interest payments get paid while this loan is out.
So does that matter? I mean, does it matter for the purpose of bringing the bank into Florida that the bank requested the Florida property as collateral? In other words, if the borrower would have offered up the house versus the bank asking for the house, because now isn't the bank actually asking for collateral in Florida and thereby extending itself into Florida?
But there I'll go to what the trial court, I believe, recognized, and that was there was nothing special about the fact that this property was in the state of Florida. It happened to be where they had a piece of collateral that had enough money to be able to satisfy this loan. It was their home.
So if the house had been in Georgia, I would agree with you, we have no business being here today, but the fact that it is in Florida, shouldn't that give us some kind of ability to reach the bank?
No, because the U.S. Supreme Court law from Burger King and all the other courts cited below say that for minimum contacts purposes, the contacts can't be random or fortuitous. And fortuitous is the word that the trial judge used below when he was describing the location of the property and the fact that it happened to be in Florida. This was an Oklahoma bank that does virtually no business that touches the state of Florida in any way, and we went through all of it in the brief. I can.
But I think, you know,
through it
if we were looking at something being fraudulent, it'd be more like the borrower asking to have the bank take these things as collateral so that they can't be gotten to. But if the bank is asking, I think it makes a different, I don't know, that seems to me that might give us a different perspective.
I think it probably goes to the merits of whether or not they had any intent to defraud anyone, or whether they were doing anything wrong. I think, just like I'm trying to portray, and we tried to portray in the brief, we don't think the bank did anything wrong. They made a loan, and yes, it was to someone who's a shareholder, not an insider, by the way. You can look at the definition in the fraudulent transfer statute of what an insider is, and a minority stockholder fits none of those things. He's not a director, he's not an officer, he's not an employee, he doesn't direct the operations. He fits none of the hallmarks of what's considered to be an insider.
So let me ask you the same question I asked you opposing counsel, which is if we were to find that this does fall within the long arm statute and the trial court did not rule on the due process minimum contacts issue, should this be something that goes back to the trial court, or should we rule on it based on what we have?
I believe you can rule based on what you have, and I think you have a single fact that the parties agree to, and that is that this mortgage was on a piece of Florida property, and the decision you'll have to make is
that enough?
Is that enough? And we say no. We say there has to be more. We say that it was random. We say that the bank wasn't intentionally trying to come into the state. They didn't do the combination of the collateral that they had, which was going to cover the payments being made, and also the fact that it did happen to be a homestead, so that they could rest reasonably assured that they wouldn't be hauled into any litigation. I guess there could be a code enforcement case or something like that.
Does the value matter? The value of the home?
Only if we get to the merits of whether or not there was reasonably equivalent value for the transfer, which we believe that there was. And by the way, just to get to the difference between the two types of claims on a fraudulent obligation, which I have a hard time finding any cases that describe what that actually means. The only cases I can find is where they actually didn't make the loan. It's like just an absolute sham loan. They gave the consideration. The obligation is $3 million. In order to fit Chapter 726, the predicate is that there has to be no reasonably equivalent value given in return. Here, we know that's the case, and I just wanted to point that out since we're talking about their claims. But the answer is simple. On minimum contacts, is this mortgage just this mortgage enough? Because that's all that there is.
Let me ask you one other question. Assuming we rule in your favor, is there a way that Wells Fargo could get at the same assets by maybe domesticating its judgment in Oklahoma and then proceeding up there?
It had already done that. They had proceedings going up to a final hearing, and 3 days before the hearing, they dismissed them and came down here to try their hand in these proceedings supplementary. But the claim has always been about, because they can't get to the homestead, trying to get the bank stock and the deposit accounts owned by Mr. Carballo, which exist in Oklahoma only.
Is there anything in the record to indicate that the property, meets Florida's requirements for homestead? Is there anything in the record? Because I know you argue that the Florida property is exempt homestead property and therefore couldn't serve as the subject for the proceeding supplementary. But was there anything in the record to really establish the fact that this property met the requirements for homestead?
There's a lot of paper in the record, Your Honor, and it was never an issue because no one ever questioned it. There's a husband and wife who have lived there for a number of years. It's their primary residence. I can't point you to a page in the record where that is, but I've never heard Wells Fargo or anyone else question that is the case. If there are any further questions, otherwise, I would urge you to affirm the decision in all respects.
Thank you.
Very quickly, Judge May, I think that's a terrific point that, in addition to the points I mentioned, Prime Bank requested specifically this property. That's another factor as to why they have connection. They availed themselves of Florida. They required this particular collateral in Florida. Judge Taylor, I don't think my colleague directly answered your question as to whether the statute, the plain language of the statute, says that it needs to be a direct action on the mortgage. Plain language of the statute doesn't say anything like that. It says arise from. He answered what the causation standard is in the case law, and as I say, yes, the case law is actually weaker than actual causation. The case law would allow for a connexity or a direct relationship. It doesn't require actual causation, but here we have actual causation because but for that mortgage, you wouldn't have this lawsuit here today. It's true that but for the mortgage, you wouldn't have those loans, but the same direct relationship exists. But for that mortgage, this lawsuit would not have arisen. And so there's a direct but-for relationship there as well. Our but-for example does work. I would say I don't want to get into the merits because I don't think we need to win the personal jurisdiction appeal. The merits is for another day down the road. But it's interesting that their argument on fraudulent transfer on the merits actually underscores why we should at least survive personal jurisdiction, because their argument is they won't win on the merits because there is a homestead exemption here. I'm sorry, can I finish this
Please
once?
do.
There's a homestead exemption here. Well, it's that homestead exemption that they are taking advantage of in creating this collateral package to move into Florida and particularly choose a homesteaded property. And so their argument on the merits actually underscores why they have availed themselves of Florida homestead law and use that to try to build a bigger collateral package that better protects them. I'm out of time, so I would ask you to reverse and remand. Thank you.
Thanks, folks. And we will be adjourned.